Buckle up, guys. Today we're diving into a case straight out of Florida, featuring a defendant who thinks is smarter than everyone else in the room. Right from the start, you can feel the tension brewing. This guy is facing some serious drug charges but insists on representing himself. The judge is calm, trying to set the stage, but it's clear he knows what's coming. A legal train wreck. The moment the defendant opens his mouth, it becomes obvious he has no real understanding of courtroom procedure. He's trying to dismiss charges on the spot without even following the proper legal process. This is classic sovereign citizen behavior. Lots of talk, zero legal foundation. The judge quickly shuts it down, reminding him that only properly filed motions count. Right away, we know this is going to be a long, messy hearing.
Your Honor, this is Jason Walterman, 24 CF 1518. You asked to put him on towards the end of today's docket.
Yeah, I just didn't want to do the Ferretta hearing because it takes a while and leave everyone else waiting.
Yes, Your Honor.
All right, Mr. Walterman, what are you asking the court to do?
Dismiss these charges.
Well, that's not what we're here for. No, that's not going to happen. I don't get to dismiss charges unless a motion is filed.
Yes, I filed a motion to suppress and a motion to dismiss. I guess it's not reached again, the mail from the jail.
Y'all seen anything?
This will be the second time I've submitted it.
Well, the issue is, Mr. Walterman, is that you're represented by counsel. And so
Yes.
when you file things, when you're represented by counsel, unless they're adopted by your lawyer as motions they want to pursue, then they're a nullity. It's like they never happen. They get struck. So other than dismissing the case, what are you asking for?
You reviewed discovery, see it's been amended several times due to the unlawful traffic stop. Everything that's supposed or alleged evidence is inadmissible in court. The charges are completely fraudulent. I did not possess a gallon of methamphetamines nor a gram of fentanyl at all. It was a targeted...
Mr. Walterman.
Yes, sir.
Earlier, you said you wanted to talk to me about either representing yourself or getting a different lawyer. So that's what I brought you back to talk about.
Yes, sir. Yes, I asked counsel to put these motions in with the case law, and I did all the work and told her about it. She didn't submit it, so here I am. I guess I need to represent myself. I don't want to be another statistic.
Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
So help me God.
All right. Can you state your full name and date of birth?
Jason Michael Walterman, 79, 45 years old.
Here we see the first clash between the defendant and the court. The man claims he filed motions to suppress and dismiss evidence. But there's a problem. He's already represented by a lawyer. In legal terms, this makes his self-filed motions a nullity, meaning they basically don't exist. The judge explains this patiently, but you can sense his frustration growing. The defendant refuses to understand, insisting the motions should still count because he submitted them twice. This shows a deep misunderstanding of how the system works. If your lawyer doesn't adopt your motion, it's legally meaningless. The judge makes it clear that this is how the law works, not just some random rule he invented. But instead of listening, the defendant doubles down, setting the stage for a massive courtroom meltdown.
And so, Mr. Walterman, do you understand that lawyers have an ethical obligation not to pursue motions that they don't think that they can't in good faith think they're going to win? You understand that?
I realized that it's working against me. That's for sure.
That's not what my question was. My question is, do you understand if you ask your attorney to file a motion that he or she says, I don't think I've got a good faith basis to file, they're not going to file one because it would be unethical for them to do so?
I guess that's why we're here today.
Okay.
Needing to relieve
But
my counsel.
again, my question is, do you understand that?
Do I understand that it's, that she didn't want to put the motion in for me?
I asked you a question. I asked if you understood it. That usually involves a yes or no answer.
Yes.
Okay, so you do understand that. So you've asked to file, or you've actually filed your own motions, but since you're represented, they're a nullity. Okay?
I must submit those?
Unless you're representing yourself. But I have to go through what's called a Feretta inquiry to find out if I think you're able to represent yourself. So, again, what are you asking for today?
I would like to represent myself.
Okay.
Do not
Why?
believe that the council has my best interest at heart or.
All right, so the issue, do you want to represent yourself, or you just have an issue with your current counsel?
You know, I realize the state's attorney's office is running the whole program between the sheriff's department, the public defender's office, even the outreach or conflict counsel. And, you know, as much corruption as I've seen them operating at, I don't feel safe with any of them handling my life. Manufacturing charges, tampering with evidence, falsifying police reports and certified documentation, targeting individuals, me especially, defamating my character publicly, personally.
Why do you think you're being targeted?
That I have not figured out yet.
Now, the defendant starts arguing that the traffic stop which led to his arrest was unlawful. He claims all the evidence, including a gallon of meth and a gram of fentanyl, is completely fabricated. According to him, the charges are fraudulent and is being framed. This is a bold claim, especially considering the scale of the drugs involved. But here's where things get even stranger. He says this was a targeted attack against him personally. When the judge asks why he would be targeted, the defendant has no answer. This is a classic tactic: claim conspiracy, but provide no proof. At this point, the judge is trying to keep things on track, but the defendant's paranoia is shining through. It's clear he doesn't trust anyone in the system, including his own lawyer.
I'm stuck with no resources, and, you know, I don't have any law library, real.
Yeah, but you understand that you're currently in jail because you failed to appear for your
Yes, sir.
trial date.
I sure did.
All right, so are you trying to represent yourself?
Yes, sir.
That's what you want. Okay. How far have you gone in school, Mr. Walterman?
Almost the 12th grade.
If I asked to verify information, I'm not trying to be offensive or anything like that, Mr. Walterman, but what you said was you didn't finish high school.
No, sir.
Did you get your GED?
No, sir.
And do you have a career field?
Professional construction worker, supervisor, superintendent.
Okay. And when's the last time that you've worked?
6 months ago, something like that. I've been in jail for about 5 months now.
Okay.
This has cost me 2 jobs already. My vehicle, my place to stay twice.
I'd appreciate if you would just stay on track with what I'm asking you, Mr. Walterman.
Yes, sir.
Have you ever represented yourself before?
No, sir. Not in a court of law.
Okay. Even in a traffic ticket or anything like that?
I don't believe I've been to no traffic court.
Okay. Do you understand that you have a right to a lawyer?
Yes, sir.
And you understand that one has been appointed to you already?
Yes, sir.
But due to your concerns about what you said with the corruption, you'd like to represent yourself, is that right?
Yes, sir.
Even though the state of Florida pays for the lawyer for you?
Yes, sir.
Okay. And do you understand the advantages of having a lawyer?
No, sir.
Okay. So, say again?
I said, no, sir. I haven't received any advantages.
Okay. So a lawyer's legal knowledge and experience may favorably affect things like bail and pretrial release possibilities, may result in obtaining information about the case through skillful use of discovery devices, may uncover potential violations of constitutional rights, and take effective measures to address them, may ensure compliance with speedy trial and statute of limitations provisions, and may identify and secure favorable evidence to be introduced later at trial on your behalf. Do you understand all those things?
Yes, sir.
Okay, but you don't want to have a lawyer do that for you.
Constitutional civil rights have been violated to a serious degree already. I think I got my best interest at heart. If I had the law resources, I could skillfully and professionally present the actual facts of the case, and that should be enough to abolish my charges and set me free.
Hey, the real issue comes to light. The defendant doesn't want a lawyer at all. He believes the entire legal system is corrupt, from the state attorney's office to the sheriff's department. He claims everyone is working together to destroy him. This is a common theme with defendants who represent themselves. They see corruption everywhere, except in their own actions. The judge tries to steer the conversation back to facts. He asks the defendant if he understands why a lawyer might refuse to file certain motions. The reason is simple. Lawyers can't file motions they know are baseless or unethical. This isn't a conspiracy. It's literally part of their professional duty. But the defendant doesn't get it. He takes his lawyer's refusal as proof that she's working against him. This misunderstanding is what pushes him towards self-representation, which is almost always a disaster in felony cases.
What do you know about the Florida Evidence Code?
What I know about the Florida Evidence Code,
Yes, sir.
I can't say that I know anything about it.
Okay.
I haven't had access to any of my evidence except for the discovery. And then the times that I discussed my discovery with my counsel, the discovery got re-amended again and again.
Okay, but how do you think it's been amended?
It says so right in the
I understand, but what changed?
the amount of people that was at the stop to begin with.
Why do you know? How do you know how many people were at the stop?
I was present.
Okay. So, because I'm reading in your motion that you filed to suppress evidence that you said there was 12 to 15 law enforcement officers on scene within 6 seconds of them pulling you over.
Yes, sir.
So
We were sitting still in a parking lot when they come into the parking lot with no lights.
I'm not asking you about the facts of your case, sir.
Yes,
I'm
sir.
just trying to make sure I understand your issues with discovery.
Yes.
If you know that there was 12 to 15 law enforcement officers there, what's the issue with them amending to make sure all of them are listed in discovery?
Well, they didn't present the evidence until I said something about it. There was just one account or two accounts of an officer on the scene where it took me saying something for them to add some more officers on there, which still there's only one account of video footage. When there's that many officers on the scene, there should be that many video accounts plus their vehicles. You know, they exist and they were there. That's part of the evidence that's not being presented. Also, the arrest report has Jason Walterman. My name is Jason Walterman, spelled wrong. My description is wrong as well. And there's many discrepancies and false statements in that arrest report.
Mr. Sheik, do you know how many discovery exhibits the state has filed?
I believe there are the original discovery and then two amended, Your Honor. One was just adding more of the officers that were present on the scene, and then the other one was the FDLE report.
The conversation now shifts to the defendant's background. The judge is trying to determine if this man is even capable of representing himself. It turns out he didn't finish high school, doesn't have a GED, and has zero legal training. His only professional experience is in construction work. This is a massive red flag. The judge also points out that the defendant has been in jail for 5 months, which means he hasn't had access to proper legal resources or law library. Despite this, the defendant insists he can handle his own defense. This shows a level of overconfidence that's almost dangerous. Representing yourself against experienced prosecutors is like walking into a boxing ring blindfolded. You're going to get knocked out, and fast.
So, Mr. Walterman, I'm looking at the discovery exhibits because you said they've added a bunch of officers.
No,
From my reading of it, The only one they added on the amended discovery exhibit was a Deputy Langer. Everyone else was already listed, and if you read on the actual exhibit, it says, this amended discovery adds previously unlisted Deputy Sheriff Langer and recategorizes the deputy sheriffs who were previously disclosed in initial discovery dated 8/6/24. So it only added one person. It just recategorized people as they need to be under Florida Rule of Procedure 3.220. The second amended discovery added an FDLE chemist, who I'm assuming tested the substances to determine what they were. So there's only one new law enforcement officer that was added, and you made it sound like there was 12 to 15.
I'm asking where's their accounts of being on that scene? When it only shows those few officers where there was a whole lot more. Like I said, but before I could put the gear shifter in park, there was a splash of a targeted, coordinated event, not an everyday ordinary traffic stop as my counsel told me it was. My tag light was not out of place, nor was the tag. It was right on the bumper.
I'm not asking you anything about the facts of the case, sir. Mr. Walterman, have you ever seen a criminal trial? Have you ever seen jury selection?
No, sir.
Do you think it might be an advantage to have a lawyer who's participated in trials and jury selection to aid you through this process?
I couldn't afford an attorney that was in my interest.
You understand that at a trial you have the right to remain silent?
Yes, sir.
And do you understand at a trial you have a right to testify and tell your side of it?
Yes, sir.
Do you think it might be an advantage to have a lawyer to counsel you on as to which one would be better for you and give you the pros and cons of those things?
Yes, sir.
Okay.
Had a lawyer, but I didn't receive any sureties or counsel of upholding nature.
I'm not sure what you're saying. You're going to just be a little louder, Mr.
I
Walter.
wasn't presented with any factual knowledge or, how to guide this case with counsel, other than she wanted me to commit perjury and be extorted for $1,000 to accept 2 felony drug charges that I didn't possess any drugs for to begin with.
She wanted you to commit perjury and be extorted.
Well, that's what admitting to guilt would have been committing a crime to say I'm guilty. That is perjury, isn't it?
Here's where the judge really lays it out. He explains, step by step, why having a lawyer matters. A lawyer can negotiate bail, challenge evidence, and make sure constitutional rights aren't violated. They can also track important deadlines and call witnesses on your behalf. These are critical skills that take years to develop. But the defendant isn't convinced. He claims his constitutional rights have already been violated to a serious degree. So he believes he's the only one who can fight for himself. This is pure emotion talking, not logic. The judge even uses a powerful analogy. Representing yourself in a felony case is like trying to perform brain surgery on yourself. It's a terrible idea, no matter how confident you feel. Sadly, the defendant doesn't seem to get the message.
Well, Mr. Walterman, most people who enter a plea in my courtroom end up pleading no contest, which means they're not admitting their guilt, and they're doing so because it's in their best interest. Not admitting their guilt at all.
But I am not guilty.
Oh, I understand. I'm just... Do you understand that a lawyer can call witnesses for you and make sure they come to court? I need an answer, Mr.
Yes,
Walter.
sir.
Okay. The microphone doesn't pick up nodding.
Yes, sir.
Do you feel that you could question witnesses who appear against you?
Yes, sir.
Okay. Have you ever cross-examined a witness before?
No, sir.
So based on my earlier questions about knowing the evidence code, wouldn't it be helpful to have someone who is familiar with the evidence code question the witnesses?
Would most certainly be helpful.
Okay. But you don't want that advantage.
Yes, just counsel would be just fine with me. I was stating I haven't received that.
Okay. But again, I've asked you if you had an issue with your lawyer, and you said you just want to represent yourself.
Well, my best interest wasn't being looked out for. That's why I was needing to.
How so?
I did the work, studied the case law that backed up the findings for my plea of not guilty for every account with extra backup on it. Gave her the motions or told her.
Case law for your plea of not guilty?
Well, that was backing up the case that I'm fighting right now for my freedom, and the charges that was put against me, stating what made those charges not of any merit or substance, and I wasn't getting nothing but this is the best I can do, plead guilty to something you're not guilty of. Okay, to target individuals in Florida to do this type of extortion or bullying or gang stalking. Or
Who's gang stalking? What does that mean?
it's where a group of individuals conjure or coordinate coincidence to attack a being, to take advantage of it.
You're saying someone's doing that to you?
The focus now shifts to evidence. The judge asked what the defendant knows about the Florida Evidence Code, which is basically the rulebook for what can and can't be used in court. The defendant admits he knows nothing about it. This is a major problem because evidence is the backbone of any case. The defendant then claims there were 12 to 15 officers present at the traffic stop, but only a few were listed in the official reports. He argues that the discovery, the evidence given to both sides before trial, has been repeatedly changed. However, the judge patiently explains that the only actual change was the addition of one officer's name and a crime lab report. This shows the defendant is either confused or deliberately twisting the facts to fit his narrative.